and welcome to another of our short teach-in videos. My name is George Dunn, and I'm the Chief Executive of the Tenant Farmers Association. And this teach-in is part of a series through which we seek to shine a spotlight on topical issues being faced by the tenanted sector of agriculture, and it's part of our growing YouTube library, which also features webinars and important industry updates that you can access. So don't forget to let us know your thoughts in the comments section below. And if you found this video useful, why not subscribe to our channel so that you don't miss out on any of the new content as it gets produced. Today, I'm really pleased to tell you that we're going to hear from one of our specialist TFA rural surveyors, Adriana Vaux-Chan, and she will be highlighting the risks involved in allowing farm workers to live in a farm cottage on a tenanted holding and what you can do to mitigate those risks. But before we start, I'd like to say that we're absolutely delighted that Roythorn's solicitors are sponsoring our 2025 virtual teach-in sessions. For those of you who may not know Roythorn's, it is a national law firm steeped in agriculture. They've got over 90 years experience advising landowners and tenant farmers alike. Their lawyers are active in many farm tenancy policy groups, and so they can get the bigger picture. So whether it's about succession, or it's about new farm business tenancies, or a dispute with your landlord, a share farming agreement, or a collaborative natural capital agreement, Roythorn's is there to advise and assist. So, moving on to today's teach-in on mitigating the risks involved in allowing farm workers to live in farm cottages on a tenanted holding. I should say that this is being recorded at the beginning of 2025, so everything we cover today is correct at the time of recording. So for advice on your individual circumstances, we recommend that you call TFA head office and speak to one of our team of advisors, such as Adriana. So I'll introduce you now to Adriana, who, as I said, is one of our specialist rural surveyors here at the TFA. Welcome, Adriana. The floor is yours.
George, thank you for that introduction, and welcome everyone to today's presentation, which is going to be highlighting the risks involved in allowing farm workers to live in farm cottages on tenanted holding and provide you with insights for mitigating those risks. So firstly, what are the risks? Well, the first risk is enhanced protection for the employee of the cottage. So that essentially means that without following a very set procedure, it could mean that you could find that your farm worker becomes a protected occupant, meaning that it's incredibly difficult to get back possession of the holding, as often these workers even have succession rights. Then there's also potential breach to your tenancy agreement, because most tenancy agreements do not allow tenants to sublet, and therefore by allowing a farm worker to reside in a farm cottage, this is subletting and therefore a breach of the tenancy agreement. Under an AHA tenancy, this could mean that you become vulnerable to a Case D or even a Case E notice to quit, with the former being remediable and the latter not, and this will entirely depend on how hard your landlord wishes to be. It is very difficult to remove the employee from the cottage because as a farm worker, they have extra protection rights, and it is very difficult to remove them even after their employment ends, because their rights will continue through statute. Farm workers who started occupying the cottage before the 15th of January 1989 have slightly different rights to those who occupied after this date. And also, finally, potential breaches of government regulations. This means that subletting to a farm worker means that you, the tenant, become their immediate landlord, and therefore responsible for regulations such as the minimum energy efficiency standards, and therefore responsible for bringing the property up to standard. As the farm tenant, you are also likely to require the consent of the landlord under the agricultural tenancy to make any necessary alterations. So in order to protect yourselves as the farm tenant from granting a farm worker a tenancy which creates all of those extra rights, it is essential that you grant an assured shorthold tenancy. However, after the Renters' Rights Bill, which is due to come into effect after spring this year, assured shorthold tenancies are being abolished, and therefore tenancies will become assured tenancies. However, even granting the more favourable assured or assured shorthold tenancy to a farm worker means that the farm tenant will have to comply with and fund very specific compliance and safety regulations. Next slide, please, Julia. So these are examples listed out below. And as the immediate landlord, you would be responsible for complying with all of these. If you want to phone into the TFA head office, we can advise you on these, but it is really important to have this as a checklist when you're considering taking on a farm employee. Next slide, please. So it is really essential that you need to mitigate any risks to your farm tenancy. So before you take on a farm worker, you need to check whether your tenancy agreement can allow you to sublet to an agricultural farm worker. And this is something which us TFA advisors can do for you. So you just need to phone into head office. Either we'll have your tenancy agreement on file, or you can send a copy in for us to review. Secondly, it's important to ensure that the farm worker is put on a formal, so that means a written tenancy agreement. That's to prevent it from becoming an assured agricultural occupancy. And this is incredibly important. We get a lot of members who want it more informal and low key, but actually that's what causes difficulty. So it's really, really important that you get a written tenancy agreement put together. And also, whilst you're putting documents together, it's important that you obtain what's called a Form 9 notice. And this should be served before the tenancy starts on your tenant and before they move into the property. So a Form 9 notice combined with assured short-hold tenancy or assured tenancy agreement before the farm worker even moves into the property. And then it's really important that the tenancy is obviously carefully documented, the condition of the current property before the tenancy starts. And it is also important to note that the farm worker must pay you rent, and this must be no less than £250 per year for their occupation to be classified as an assured or short-hold tenancy, because that is one of the criteria. And failure to do this means that they will then fall into the category of being a protected tenant, which we're trying to avoid. Next slide, please. Finally, a helpful way to defend yourself against any disputes by your landlord is to have some legal expenses insurance in place, as this really enables you to stand your ground and fight your corner, as any form of dispute can be incredibly expensive. The TFA does have a policy, which if you wish for further details, please contact us. But I just want to give you some key take-home messages, which is obviously check your tenancy agreement before you make any decisions, and we can do that for you. Check what it would cost to meet any repair, maintenance and regulations for subletting to a farm worker. Because as you've seen above, there is a lot for you to comply with, and these can be very costly, especially considering that often farm cottages are the ones which need the most work due to the state of them. So you might find that it actually costs a lot of money for you to put these into the necessary repair in order to sublet to a farm worker. And then finally, follow the correct procedure for subletting, even if it is with family and friends, and that is Form 9 notice and a formal written tenancy agreement, and obviously the rent of a minimum of £250 per year. Thank you.
Adriana, that's brilliant. Thank you for that. It's clearly a very complex area and not something that members of the TFA would necessarily understand at first blush when they're thinking of bringing on employees. It's really important that we get all of that right. So just a few questions. So let's say I am a tenant on a Agricultural Holdings Act 1986 agreement with 3-generational succession. What's the worst that can happen if I've sublet and my tenancy says that I shouldn't have done so?
Yes, this is a tricky question, and sadly one which we do get quite a lot, and there is no easy way of saying this, but you could be incredibly vulnerable to receiving one of those harsh case E notices to quit, which would be given by a landlord or agent who chooses to be particularly hard on you, as this is for a irremediable breach, which means that the landlord's holding has been deemed materially prejudiced by the tenant because of their activity, which in this case would be subletting. However, a tenant is always advised, if they receive such a notice, to immediately seek help not even leave it a week, immediately. And that can be by contacting us at the TFA or your agent and solicitor. And it is vital that you make sure that you apply for arbitration within 1 month of receiving that notice. And then within 3 months, apply for the appointment of an arbitrator. This is really important to protect your position, and it allows you then to defend what you need in order to make sure that this notice doesn't come into effect. Alongside this, a tenant can also consider negotiating with the landlord, as it will be in the interest of both parties to reach a resolution in order to avoid very costly litigation.
Okay, so I've looked at my tenancy agreement. My tenancy agreement says that I cannot sublet, but I still want to allow my farm worker to live on the farm and the cottage that's there. Is there any way around this to make sure I'm not in breach of my tenancy?
Again, this is a tricky question with a tricky answer, because there is no easy way around this. Therefore, the best course of action is to firstly request consent from your landlord for permission to house your farm worker on an assured shorthold or assured tenancy. However, if this is not possible, then the only other option is to make sure that your farm worker does not have exclusive occupation of the cottage. And therefore, ways around this are limited and often not the most favourable to yourself as a tenant, because you'd have to have them as lodgers, providing bed and board, or workers sharing accommodation with yourselves or other people in the business. This means that they don't have exclusive occupation, which is what we're trying to avoid. The only caveat to this is that some tenancy agreements may still prevent these options from being possible, and therefore it is vital that you check the tenancy agreement before getting a farm worker in. It is also important to note that the well-known occupation, such as known as service occupancies, will not work for agricultural workers, because these workers can still acquire rights as an assured agricultural occupier. So that is important to note.
Okay, so another scenario for you. My landlord wants the farm worker who lives in one of the cottages to leave, but the worker is refusing. What should I do in those circumstances?
So if the farm worker has protected status, it is hard to remove them. However, not impossible. You could try and reach a negotiated agreement, such as a monetary deal to leave, or you could see if you can assist with suitable alternative accommodation elsewhere on a short hold or assured tenancy. If those do not work, then you may have to work directly with your landlord to go down the route of seeking a court order for repossession if the farm worker has turned down your offer of suitable alternative accommodation.
Thanks, Adriana. Time is against us, so we're going to have to leave the question and answers there. But for those of you watching, if you've got any more questions around your individual circumstances, then you can join the TFA as a member. And currently, membership starts from just £299 per year. So it is excellent value for money. And this gives you access to dedicated advice, information, and support from experts just like Adriana. So for more information about the TFA and how we can support all farmers in England and Wales who do not own the land that they operate, you can visit our website, www.tfa.org.uk, and there you will find information about our upcoming calendar of events, as well as all the latest news affecting the tenanted sector of agriculture. We hope that you've found this teaching helpful and useful, and if you are watching on YouTube, it is part of our growing YouTube library, so go and have a look at what is available there. Let us know in the comments below if you've got any thoughts about this short video, and don't forget to like and subscribe to our channel so you don't miss out on any new content as we make it available. Many thanks again to Roy Thorne Solicitors for sponsoring our virtual program of TFA teach-ins and webinars, and thank you for joining us on this one. All the best.